Hello, everyone. I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. I understand I'm wearing bib overalls today. I'm going live for 1 hour, and then I will have exactly 1 hour left of sunlight to get things done on my farm. And I'm not going to lie to you. It is maple tapping season, and I want that sweet, sweet liquid gold. And I can have it all. I can answer your questions and get my liquid gold if I schedule this properly. But to do that, I must be ready. And it's still a little cold and wet out here. So we got the overalls out. Doing a maple walnut syrup this year, as a matter of fact. Now, hello, Rhonda Johnson. Hello to you. All right, we got a question here from YouTube user TV Ratings Guy, who asks us if one of the associate attorneys at a big law firm who represents employers is put on secondment, resulting in her workload being redistributed. Can you share why this might happen? Thank you. Could be a medical leave, could be a maternity leave, could be, could be a discipline. She could have gotten into trouble, had an affair in the office. I don't pretend to know. There's so many things that could cause that. Could be she's on a sabbatical. Could be she's getting her certificate as a yoga instructor, and she's currently on a retreat, learning the finer parts of expanding one's mind and flexibility. Right? I don't know. TV Ratings Guy has a second question. If she had been, if that same big law attorney had been licensed to practice for nearly 10 years, and is an associate at a big law firm, would a secondment assignment be a positive or negative thing for her career? Well, big law doesn't like, let me just make sure I understand how you're using secondment, because I'm not the most familiar with that phrase. So a secondment is a temporary work arrangement where an employee is assigned to a different role, either within their organization or with another organization, while retaining their original employer and salary. Yeah, I mean, listen, she could be shipped to a client of this big law firm to do an in-house general counsel role for a period of time because they're between general counsel. I don't know. It could be an amazing opportunity for her, or it could be a huge step back in her career. I can't say, unfortunately. Yeah, I guess that's the answer to your question. And then, okay. I guess it was all one big question because you ended by saying any insight from a lawyer's perspective would be appreciated. Thanks, Vince. I gave you my thoughts as the best I can manage. I know it wasn't much, but I tried. Choose Compassion says, hello, Vincent. You're looking farm ready. Thank you. Thank you. Yeah, it's I got to really earn my overalls today. My overalls are a little too clean, but I poured a bunch of freezing cold maple sap down my boot yesterday. So we're getting the overalls out. YouTube user, says, what happens after a state FMLA hearing officer makes the final decision and awards damages? Well, I don't. Okay, so you're asking me a question about State Family Medical Leave Act, which must mean that you're under some statute. You're in a state that has family medical leave. The Family Medical Leave Act is the Family Medical Leave Act is a federal law. It's a federal statute that gives you leave rights, and that is true in the entire country. That applies to the entire country. Now, there are also states that have family medical leave statutes and processes by which these are adjudicated. One such would be New York State's PFL, the paid family leave, right? In each of these states, the statute is different. The process is different. Everything is different. So you're saying, hey, I'm in a state with an FMLA issue and they have hearing officers making a final decision. What happens next? I don't know. I don't know what state you're in. And I probably couldn't tell you. I probably would not be allowed to tell you about the state laws of that state without having local counsel of that state here. We answer questions generally about federal law, but you're saying essentially they made a final decision and they awarded you damages. Sounds like you have to, in most states, and check with local counsel, right? You have to enforce that judgment and collect your damages. Unbeknownst Guy says, how does the process of appeals work? Nope, we don't do appeals on this channel. Let's stop reading. Yum Magic Maple. Great to catch you again, Vince. Hello to NYC Damages. And unbeknownst, I don't mean to be rude. You got to talk to an appeals attorney about an appeal. Not an appeals attorney. Don't do appeals work. NYC Damages implores everyone to hit the like button. YouTube user Norman DePlume, whose username I figured out last Friday, finally. Michelle Cephas says, good afternoon to all. Good afternoon, Michelle. Pamaroon says, hey, cheeks. Hey, Pamaroon. I realized recently, I told this story about the judge who used to call me cheeks. And I thought she had retired. Your boy made a mistake. She's still on the bench. Should not be telling that story. Gotta shut that mouth. Me, not you. Music Underground says, I have a question. What should I do if I have a strong case, but the attorney is afraid of arbitration and wants to settle for a low amount, even though the facts prove the claims? Well, listen, have the conversation. Be like, hey, what specifically are you afraid of here? Like, why do you think this arbitration is dangerous for us? And really hear the attorney out. Then if you don't agree, great. Say to the attorney, hey, attorney, you don't want to take my case to arbitration. I don't want to settle. You got to let me go. I got to get other counsel. Maybe, though, I would recommend you find other counsel before you cut ties with this attorney. That's my recommendation. Norma DePlume says, is that a SAP season outfit? Maple Leaf? It sure is, Norma. Music Underground. The farm is going really, really well this year. We are kind of heavily in demand because of the egg shortage and the maple syrup shortage. So we produce both of those things. And it's kind of wild. There is we used to give eggs to a food bank, and the food bank started giving us $4 an egg through like a state grant, which is bonkers. And I couldn't figure out why they were giving us so much, but I guess one, it's to promote small farms in the area. And two, I guess 1 in every 5 families in Vermont, which is our next door neighbor, we're in New Hampshire, but 1 in every 5 families in Vermont is on food assistance now, which is insane to me. But I guess that's part of why they're paying so much for the food banks here, because the people from Vermont have trouble supplying their own food banks because they have so many people on food assistance, I'm told. And so they come to New Hampshire food banks, and it's just is what it is, right? Like I'm never going to begrudge anyone food. So like, I'm not going to be like, oh, those Vermonters coming to New Hampshire for food. I'm more like, yeah, I better produce more food. So the farm is doing great. And I'm going to go pick up 30 more egg layer chickens tomorrow. Actually, we're going to put them in quarantine for avian flu and hopefully increase our egg production. That'll be about 80 egg layers on the farm at that point. We have 100 meat birds coming, and we use the meat birds to clear, which we go with the Freedom Ranger breed, which doesn't grow quite as fast, but the quality of the meat is much better. And these birds are able to free range. They clear our property of ticks, and the meat is fantastic. It is the best roasting chicken I've ever had. So we got 100 of those coming. We've got turkeys coming. Tried a different breed of turkey, a more native breed of turkey this year. And we have, we believe, 2 pregnant sows on the farm right now. We recently rescued a coon pig, which is nice. She's really, really bouncing back nicely. I think that the farm we rescued her from was not able to keep up with their animals anymore. So she had lost a lot of weight. She was starting to show concave hips and a lot of lost hair, but she is bouncing back lovely. And she is a sweetheart, as long as you remember that she will 100% take your finger off. But she is lovely. And so the farm is going great. We're also building a greenhouse that's sunken down into the ground to take advantage of like geothermal, just the heat of the ground, right? And filling the bottom of that greenhouse with a false floor full of water, which is heat mass, right? The water has a high practical heat. takes on heat from the greenhouse during the day and then slowly releases it over the course of the night. And that water in the base of the greenhouse and the sunken nature of the greenhouse into the ground helps it to retain heat and stay warmer. So we're hoping to do like year-round fig trees and stuff like that, keep them alive. So the farm is going great. It's just a lot of work, but I love the work, right? YouTube user Pamaroon says, thoughts on the judge reversal of laying off federal probational employees. I don't know. I really don't know. I don't know the ins and outs of that one. People kept saying that laying off probational employees at the federal level was illegal. And I kept being like, oh, okay. Can you tell me why? And I had this conversation with like 4 or 5 reporters, and every one of them was like, because it is. Like, okay. I'm not saying you're wrong. I'm just saying I don't understand your logic. If the employee is probationary, it essentially would be close to an at-will employment arrangement. And I'm not sure why they could not be let go. So, that was confusing to me. I don't know what the judge's logic is, Pamaroon, for reversing that, but the judge might have good logic. I'm not saying the judge is wrong, for sure. YouTube user Pamaroon says your lack of coughing has improved, but keep on it. I have to have an ultrasound endoscopy. I have a blockage in my throat, a little like a nodule that grew there that's causing the coughing. Ultimately, it's acid reflux in this nodule, and having it biopsied and having some tests done. So I'm on top of it. And we do have eggs for sale. We do. We have lots of eggs for sale, certainly. YouTube user Bambino Dadon says, I have a question, Vince. My employer claims that they terminated me because I refused a work task because I asked for a helper, but they just did a training 3 weeks earlier where they told us we had to have a helper. Yeah, that's a pretext. They fired you on a pretext. So I certainly think that is a potential claim. Choose Compassion has a heart, a lightning bolt, and a wrench. I love that. Choose Compassion is, of course, one of our moderators and a tremendous help to the channel. Thank you so much. I think we actually there might be in the chat today. So we have 38 concurrent viewers and only 20 likes. And I just want to say that the likes are free. It's free to like the stream. And it's how people see us, right? But that's neither here nor there. I think that we have a potential hire in the chat today. Somebody who applied to our firm who I think will be joining our firm shortly. So that's exciting. I don't know if they're going to speak up or not. YouTube user Madeline Stevens, which is coincidentally the name of my tailor. So I suspect you're not my tailor, but hi, Madeline. For a company to claim they are implementing a RIF, do they have to meet the WARN Act requirements? They have to meet the WARN Act requirements if the WARN Act is implicated. So not every reduction in force is necessarily subject to the WARN Act, but if yours is, then you must comply with the WARN Act. Music Underground says, cheeks, LOL, laughing face. Awesome. I got you. Thanks for the feedback. Happy to help. Norma DePlume says, is it possible my incredible legal team would dump me if we lose? We need to appeal. Or an agency loses and they appeal. New court, new lawyers? Eyes. Little eye emojis. Okay, so Norma, most employment attorneys run it this way. If they win a case for you and the other side appeals, they will handle the appeal for you, or they will hire an appeals counsel to protect their verdict for you, generally. Now, the other thing that happens is if they lose the case, most employment attorneys say, hey, you can hire an appeals attorney. If your appeals attorney is successful, we will come back and take the case over again if you want, but we can't pay for the appeals attorney because the appeals can be like 20, 30 grand. Lakers in 5 says, Vince, take my case on contingent. I don't do intake in live chat. So if you want to talk to our intake people, they're happy to talk to you. nycjobattorney.com or any of our other sites, you can hit them up. They'll talk to you. There's no reason I wouldn't want to help you. Obviously, I like cases. I like helping people. There is zero chance that I'm going to do intake on a live stream. publicly being watched by 36, 38 people. Like that's just never going to happen. But certainly we want to help and we would love to. I'll finish reading your question though. The EEOC found cause in my charges, including retaliation in Louisiana, going to go the distance. Rocket ship emoji. Okay, listen, Lakers in 5, that's awesome. I hope that our intake personnel make you an offer. What do we have here? What's next? Whoa. Music Underground says, nice. I wish I had a syrup fountain. That's cool. Yeah, I mean, it's a lot of fun making syrup, and the syrup makes a fantastic gift. And it sells like a pint bottle is selling for like $30, $35 right now. And it's bonkers. Like it's not like I'm like making my living off selling syrup here, but like it's just wild to go to like a farmer's market or something. Like, so we'll sell turkeys at farmer's markets sometimes. Not me. I'm not going to go sit at a farmer's market. I got stuff to do. I got to be on here. Right. But we're getting like crazy returns for some of our stuff now. Like people are giving us like $11.50 a pound for our turkeys. And listen, we don't call them organic, but the reality is there's no hormones. There's no pesticides in our land. We're on a mountain, so there's no like farms uphill from us leaking pesticides and fertilizers down into our land. It's like a very idyllic situation for producing food, and we have the ability to control everything. We have the ability to source all the hay and straw that we want exactly from the farms that we know. We're not going to put pesticides on them. We're not using chemical fertilizers. We have the ability to get our compost from somebody that we know is creating like a perfect blend of chicken worked compost, and we're able to do all these things. And the quality and level of the food is, for my purposes, unimaginably good. Like I think the food that we produce is amazing, and a lot of amateur and professional chefs seem to agree. So, I'll leave it to them. They're the professionals. And yeah, it's very cool. And anyways, the having the syrup gets people to come over to your booth at the farmers market table, and then they're like, "Oh, you're selling meat birds?" And then they're like, "Whoa, you have a 20-pound meat bird, like a 20-pound roasting chicken? That's crazy. How do you do that?" And it's just like, it's a conversation. Then you whip out the like 30-pound turkey, and they're like, "I've never seen a 30-pound turkey." And you're like, "Well, this one's pretty good. You want to try it, It's only $11.50 a pound." And then, you can do the math, right? It's quite a turkey, right? Let me do the math. I don't want to do any math in my head on a live stream. So yeah, it is not unheard of for people to try to, for us to sell turkeys, frankly, for like $300, $345, I think. And it's just weird because we also give them away, routinely we give them away. And then people are like, "No, don't give that away. I want to buy it." Or more likely, they're like, "Why are you giving away to those people? Give them to me." We're like, "No, for you, it's $11.50 a pound. But for these people who are hungry, it's free." Okay. What do we got? NYC Damages said, "Is it normal or common that employment plaintiff attorneys don't do appeals?" It is relatively normal, NYC Damages. Appeals work is a different line of work. And generally, I want the attorneys who are best at it to do that line of work. Choose Compassion says, "Farm life, I love it." Me too, Choose Compassion. Me too. Music Underground says, "That's awesome, smirky face." Valencia says, "A judge ruled that there was enough evidence and the settlement was fair, and another judge ruled that a single plaintiff did not have enough proof to prove 2 of the 3 causes. Both employees at the same facility." Okay. Do you have a question? That might be all you wrote. So listen, there can be differences in the way the judges perceive things. It's, luck of the draw in terms of getting a judge. There can be differences in how the different attorneys for different clients presented things. It can be slight differences in the evidence. It can be differences in the jury that was selected. It can be differences in the parties and the various decisions that were made in terms of settlement. Like there's a lot of different things that go into that. Does not strike me as strange that two different parties would have different results in front of different judges with different counsel. It just, that makes sense to me. Lupe Collins says, I am pro se on a longshore and harbor death. Oh my God, I'm so sorry. I am pro se on a longshore and harbor death claim against KBR for the death of my husband, who was a contractor in Iraq. Thank you for the lessons you taught me. I won my case. Oh, you won your case. Okay. Okay, Lupe. I'm really sorry about your husband. I'm really glad you won the case. I know it's not going to fix anything. I hope it helps a little bit, though. I'm sorry. NYC Damages says, Norma de Plume, I am very interested in that question too. Appeal and legal team. I believe I answered that question about appeals. Exec Monster X says, I was awarded a judgment against a former employer who was also ordered to pay into a pension authority, which they have not done. I was taxed for all the money, yet I haven't received all. What is my recourse? You're going to have to enforce that judgment. You have a judgment. They're committing fraud in how they make good on that. So you're going to have to talk to a collections attorney to enforce that judgment locally to where you are. Choose Compassion sent congratulations to Lupe, which I love. YouTube user the BCM 4134. Also, for the record, I don't know what a BCM is. If it's something bad, I didn't know that. That's why I read BCM. So might be something harmless. I have no idea. But everybody's always trying to cancel me. So the BCM 4134 says, boss intruded on me having a panic attack. Wouldn't leave even though I asked him multiple times. Got in my face and yelled. Is this assault? Depends on how assault is defined where you are. In New York, probably not. You have to have a reasonable fear of danger, I think, in New York, although I'm not a criminal attorney. And it doesn't sound like you necessarily thought this person was attacking you, although I could be wrong. So it's going to depend on the laws where you are. And I guess the details of what happened and how you felt about it to some extent. YouTube user Open and Shut says, if I am employed in California and no discrimination occurs, but then I transfer to Texas under the same company and I face retaliation and discrimination, can I file in California? Hopefully that new mute button they installed for me works. Can you file in California? Maybe is the answer. Odds are the case would be probably better filed in Texas if that's where the discrimination occurred, and also where you currently are, and also where the company is, because you got transferred to a facility in Texas. The case is probably better brought in Texas. However, I can certainly see the logic of preferring to file this case in California, and there is logic that the if the company's headquarters is in California or something like that, you have some pretty solid arguments as to why you should be in California. So I think you can make an argument there. Choose Compassion says, hit the like button. It's free. Choose Compassion also says, congratulations to the new employee. I think this new employee is going to work out. I think it's going to be good. I think we're just about there to hiring somebody. YouTube user Gipper Boy says, thoughts on the process of refiling a case after I was voluntarily dismissed under Rule 41. Does discovery in previous case transfer to new case if claims, facts, and parties are the same? I mean, the evidence is going to be the same. So if you receive discovery in a case and the evidence that you receive, the items you received in that discovery is valuable evidence in the new case, then by all means use it, certainly. Refiling the case, I mean, in most jurisdictions, you're going to have to look at whether the case was dismissed with prejudice or without. If it's without prejudice, you can probably just refile it. If it's with prejudice, you might have lost your shot, but talk to local counsel. Oscar Alameda says, actually, I say that wrong. It's not Alameda, it's Almeida. Almeida. Hey, Vincent, always love the content. Oscar, thank you. Thank you for saying that. Choose Compassion provided Lakers in 5, a playlist on how to approach employment attorneys. Oscar Almeida says, I want to say that I finally got a response from the respondent about my settlement offer, and they relayed to my lawyer that they are not willing to engage in settlement offers yet due to the high amount I requested, but does that mean they're willing to negotiate if I were to lower the amount, or they're trying to tell you they would talk settlement if you lowered your amount. My lawyer stood strong on his position about waiting for their counter because we won't be lowering after first offer. There needs to be a counter. I think that's perfectly reasonable. You're standing strong. I see nothing wrong with that. YouTube user Upstream Swimmer says, nervous about an aviation whistleblower case, big company and little me. Yeah. So the journalist, Ariella, who I do our weekend show with, kind of said when we were filming today that she's working on an aviation whistleblower case as well right now. And I'm not going to lie to you, that did make me nervous for her. YouTube user Michelle Cephas said, love you context. My deposition, I think content, you mean. Love your content, just a typo. My deposition is next month, and I've watched your playlist, and I am ready. Michelle, super pumped for you. Rooting for you here. Love it. Norma de Plume says, we're not going to lose, but thank you for all that I never knew. Of course, Norma. Happy to help. The original Taurus says, hello, are you retired? I am not retired. I know that currently I might look retired, but no. I run an employment law firm that practices in all 50 states, help people with workplace discrimination, workplace sexual harassment. We fly employment attorneys and trial teams around the country to help people. Generally, we're a somewhat expensive option. So I urge people, talk to your local options first, get local counsel if you can. And if you don't like your local options or you don't have any, then we're, a potential option. No, I'm not retired. I'm a little washed up. You wouldn't want me to do your trial today, right? I'm not, I was never the best of the best. And even worse now. So while I'm really good at what I do, which is, I think, picking cases, which is the fundamental soul of my job, is I pick the cases for the firm and I run the firm. I'm not the trial attorney that you would want to handle your case. And I'm dressed like this because I need to collect maple syrup as soon as this live stream is done, which will be in 30 minutes. YouTube user Oscar, already answered that. Travel worker. YouTube user Travel Worker. Is it proper procedure to send federal filing a motion for default through business filings incorporated by the employer based in another state? Is it? Whoa, chat jumped ahead on me. Is it proper procedure to send a federal filing and a motion for default through business filings incorporated? So you have a default. Do you have a motion for default, I guess? I mean, I would hire an experienced process server that knows how to do this for sure. I'm not too familiar with business filings incorporated, so I don't want to speak to that. I don't know what they are. I don't know what they do. So I think, Travel Worker, I'm going to have to pass on this question because I don't have a good answer for you. I'm not familiar, though, with business filings incorporated. Could be great. Could be the answer. I don't know. YouTube user VA says, hello, Vince. Happy Friday and have a good weekend. And you too, VA. Certainly. The original Taurus says, what constitutes harassment in the workplace? Okay, so that's a complex question because what do you mean by harassment? So there is general harassment, there's sexual harassment, and there's harassment tied to a protected class, which is essentially discrimination. And all three of those things are defined differently, right? So sexual harassment is essentially coming on to someone in the workplace, right? Sexual comments, sexualizing someone, trying to trade sexual intimacy for a workplace benefit, or threatening someone in the workplace to get a sexual intimacy. We know essentially what sexual harassment is, right? Discrimination, which is, harassment tied to a protected class, is a negative workplace consequence motivated by your membership in that protected class, right? So if you are, I don't know, you have a disability. And as a result of that disability, some coworker does mean things to you, or you lose money, or you experience negative workplace issues or loss of opportunity, something like that. And that is discrimination. That is another form of harassment in the workplace. General harassment, which we often call civil harassment, is not often viewed as a very desirable claim. It can be hard to win. It's essentially just like a tort law claim that varies wildly from jurisdiction to jurisdiction, and it will be defined differently in different jurisdictions. Another kind of similar claim is intentional infliction of emotional distress. These claims are very generalized, and are generally higher risk and lower value than the first two claims I described, the sexual harassment and the workplace discrimination. Excuse me again. Madeline Stevens says, what is the name of your farm? Madeline, I wish I could tell you, but I can't. We're having some issues with some people who don't really understand how the internet works, who think that they can do things like run up on me and hug me and visit me and send me some very inappropriate photos that I don't want to receive. So I would love to just be able to tell you the name of the farm and have an open invitation for everybody. But the fact of the matter is, we're a little jumpy these days, and no one's welcome on the farm unless they're specifically living in our community. And by that I mean the town, not some kind of like cult commune or something. Just to be clear. Norman de Plume says, where there's syrup, there's a cider mill. Yes, no. There are many cider mills in the area. I do think I'm going to buy a cider press. We have a fair number of apple trees here. I think 7, which is not a huge amount of cider, but it's something. And also the cider press can also be used to make wine or, press other fruit for things like brandy and things of that nature. So, because we were looking at maybe making a peach brandy. We got a couple of peach trees here. I'm also planting 74 cherry trees in about a month and a half here. So we'll be looking at what we can make, some kind of cherry cordial, something like that. Yeah, certainly. Hip Hop Connecticut Artist says, does a New York human rights probable cause ruling mean you have the right to sue federally? No, but it might. So the New York Division of Human Rights has no ability to give you access to federal court. However, usually when you file with the New York State Division of Human Rights, your case will be cross-filed with the Federal Equal Employment Opportunity Commission. So what you need to know is that probable cause finding from the State Division, that's going to put you in for a State Division hearing. If you don't want that, if you'd rather go to federal court, you should check to make sure that your case is cross-filed with the Equal Employment Opportunity Commission. Contact the EEOC and say, hey, I want my right to sue letter. I want to go to federal court. And then contact the State Division and say, hey, thank you so much for the probable cause finding. I don't want the State Division hearing. I want to proceed on to federal court. And in federal court, you can bring your state, if you have local claims, your local claims as well, and your federal claims all in one action with that right to sue letter. I hope that helps. YouTube user By His Grace says, there are 3 employees suing the same employer. All but one employee is assigned a different judge. Is this okay? Will it be moved to the judge or overseeing the other 2? I could see it being moved for convenience, but I could also see just having different judges decide it. There's nothing wrong with having different judges decide a case. Different judges decide different cases. Open and Shut, YouTube user Open and Shut says, after 1.5 years of being unemployed, After 1.5 years of being unemployed versus Wells Fargo in San Francisco, California, my attorney was told by a defense counsel that they aren't interested in negotiations with 975 demand because I sent emails to myself. Thoughts? So they're making an argument that you stole some data, that you breached an employment agreement, and that's why they terminated you, so they don't think they have as much risk. If they're saying that, there's a really good chance they have proof that you did that. Now, that doesn't mean necessarily that you don't have a good case. It's just the defense they're going to try to use. YouTube user By His Grace says, how often do defendants ask to dismiss the case? About half the time. I mean, listen, also it depends on how the case is drafted. If the case is drafted really well, the chance that a motion to summary judgment goes I'm sorry. The chance of a motion to dismiss goes way down. A motion for summary judgment is something different. Waiting for the defendant to answer the complaint that was just served. YouTube user Desiree says, my company was using the wrong detergent on a pharmaceutical manufacturing machine, and the corrosive material left my arms with a rash and burns. How much evidence do I need to file a claim? I would speak to a workers' compensation attorney about that. I mean, it sounds like a workplace injury to me. So I'm not a workers' compensation attorney. That's not what I do. But I would recommend you speak with a workers' comp attorney because that's a workplace injury. And then also that workers' compensation attorney can tell you if they think there's a personal injury case there as well. And you can also look at the idea of an OSHA case. If they expose you to dangerous chemicals, there's something, you could have there. YouTube user Choose Compassion says, when there is probable cause found with the state DHR and they issue a right to sue letter, what's the difference between going to state or federal court? Okay, so Choose Compassion, we're going to use the example of New York State and New York City. In New York State, you have the New York State Human Rights Law, which handles a lot of discrimination and sexual harassment claims. And in New York City, you also have the New York City Human Rights Law, which is one of the best in the country and also handles workplace discrimination and workplace sexual harassment. And of course, you have federal laws like Title VII that do the same thing. All of these laws have different advantages and disadvantages. The good news is if you're in federal court, you can bring your federal claims, your state claims, and your local claims all in one giant action for the same jury with so many different paths to victory and so many different little advantages and benefits like better access to attorney's fees if you go to trial or a lower evidentiary bar, like an easy, fewer elements to prove. There's so no caps on damages. There's a lot of things that you want and you don't have to choose. So listen, the reality is if you're in federal court, you get your federal claims, you get your state claims, you get your local claims. If you're in state court, you get your state claims and your local claims. But if state court can't really decide a federal claim, it doesn't have the standing to. So there you go. The original Taurus says, if I don't have a claim, but my original termination was unfair, what should I do? Listen, first off, I'm not saying you don't have a claim. I don't have any knowledge whether you have a claim or not. Talk to local counsel to see whether you have a claim. Now, that being said, if you feel you don't have a claim, but you feel you were terminated for no good reason, you should probably qualify for unemployment benefits and you should apply for those. YouTube user Choose Compassion shares a playlist on collecting what you are owed, which is very helpful. Jim out west, Jim says, hi, Vince. Nearly 14 months ago, the EEOC filed my charge of discrimination and began their investigation. That's amazing. I'm glad to hear that, Jim. NYC, I'm sorry you have to deal with discrimination, but I'm glad the EEOC is doing something. NYC Damages is congratulating Lupe on winning her case. YouTube user Palencia says, if a judge deprived you from your evidence in a blanket form, do you ask for reconsideration or do you wait until the end to appeal? You can always make a motion to reconsider. I mean, as long as it's viable in the circumstance, I don't see why you might not. I would say, yeah, sure. Why not? I'll that's one of the things you don't want to just like lose the case because of a bad evidentiary finding when you might have been able to overturn it. YouTube user Desiree says, I was also terminated for using too many sick days, yet they were taken due to the severe rashes on my skin. I feel I was retaliated against due to bringing awareness to letting these chemicals. I don't know. I think there's more to this, but I can't find it. I think that might be all Desiree had to say. Yeah, Desiree, listen, there could certainly be an OSHA claim. You could have a local a whistleblower claim under local law as well. Certainly. YouTube user Bambino Dadon says, can you go up in settlement negotiations? You can. You can do anything you want in settlement negotiations. You better have a good reason for why you're going up. Right? Like that increase in your demand better be tied to some benefit or reduction. You've got a really good piece of evidence that came in, or your damages went up, or your risk went way down, or even it's just positional, I would recommend having a good reason to go up, but if you have a good reason, there's nothing wrong with it. YouTube user Choose Compassion provided the discrimination claims in general playlist to the original Taurus. YouTube user Oscar Almeida says, awesome, thanks for the response. I will stay patient. Oscar, wishing you luck. Joel Osario says, I'm in a settlement right now. My attorney won't speak to me. I'm speaking only with the paralegal and the negotiator. Is this okay? I don't love it, but I mean, it's loud. It's legal. I have a lowball settlement I want to take just to get this done. Okay. I mean, listen, if the paralegal's doing a good job, it's not the end of the world. I think you deserve better than that. But, you know, you firms are allowed to use paralegals. And while I think that is silly to use a paralegal to run a negotiation in the realm of employment law, and employment law is different than PI or whatever, like different fields. We're a very complex form of litigation. A lot of things can happen very suddenly. So for my purposes, I want attorneys handling negotiations. I'm not degrading paralegals in any way. I know some paralegals who do amazing work. It is my personal preference to have attorneys handling the negotiations, in part because attorneys tend to have some kind of profit share or incentive plan on their caseload. So they're, really motivated to win you more money, but also the attorneys have a better eye for like what's going to happen if this goes to trial. Right. And that can inform the settlement strategy a lot better. And paralegals, don't really go to trial in most fields. So that's somewhat impaired because they might not have the same depth of knowledge. B. Freeman says, 2 questions. I will answer both. 1, you had mentioned it, but can you please do an NLRB video on what you think could happen to them with all the challenges and changes they are currently facing? I think I did. I think I chatted about the National Labor Relations Board in a video I made, and I also think I chatted about it with the journalist Ari Steinhorn in our weekend shows a couple different times. 2, why would an employer fight a wrongful termination case when he knows the evidence I have against them makes it a no-win situation for them? Well, I mean, first and foremost, if they don't fight, they lose guaranteed. 2, they might not agree. Like your opinion of the evidence might not match their opinion of the evidence. It might be that you're entirely correct, right? And that they just don't know it yet. It might be you're entirely correct, but their attorney is lying to them and saying, hey, keep paying me. We're going to beat this easy. It could also, listen, a common thing is people call me up and say, I got the best evidence, all the best evidence. Oh my God, my case is 30 mil. And then you look at it and you're like, wrongful termination is not even a claim. What are you talking about? And I know when you say wrongful termination, you probably mean like workplace discrimination or sexual harassment or retaliation, something like that. But like, there are people who just think like, I was fired unfairly. Okay. If you were an at-will employee, that is not a claim. Like if they like woke up and they were like, Vince, I just don't like you anymore. Get out of here. You're done. That's unfair. That you could argue is a wrongful termination. That is worth $0. That has no value unless you apply for unemployment, which maybe you will get, right? YouTube user Lupe Collins is thanking everyone for their congratulations. Isaac's Trade says, Vince, my guy. Isaac, my guy. How we doing? And those overalls are fuck yeah. Thank you, Isaac. I got a little sapple, a little maple sap all over me yesterday. So I'm opting for the overalls today. YouTube user Ambi Lee appears to be retracting her question, so I will not answer it. YouTube user Upstream Swimmer says, I'll contact Ariel. All right. YouTube user David Almendarez says, is there incentive for some defense attorneys to not settle, even if the plaintiff is offering a low reasonable settlement offer, which is lower than further court cost? Yeah, there is a perverse incentive for defense counsel. They want to keep billing sometimes. So a lot of times they will stretch a case out to keep billing. And these are the bad firms. Like most of the firms aren't going to do this. And most defense attorneys are more interested in keeping their clients happy and getting cases put away and getting more business from their clients. But there's definitely defense counsel who would, listen, I've had defense counsel say, like, can you put a motion in? We'll settle this, but I need to put a motion in. Let me wet my beak. And it's just like, okay. I mean, you're really getting out there, right? Like this is Very upfront. You're saying the quiet part out loud, that you want some money out of your client before you cut my client a check. Now, listen, at the end of the day, I have a fiduciary duty to my client, and they're telling me like, oh, I'm going to give your client a check. All you got to do is get this motion in for me. Okay. I'll make that motion in because that's what's good for my client, right? Do I feel bad for their client? Big employer. Allegations are they did some bad things. Are they getting robbed by their attorney? Yeah. Do I like pity them? You know, but you do hate to see attorneys get greedy like that. YouTube user JH says, how does summary judgment work? Well, JH, you're in luck. We actually have a video on the topic of summary judgment. I think we have a number of videos on summary judgment on the channel, and those videos are going to create tens upon tens of minutes of content explaining this in depth and doing a much better job that I can do in a live stream. So, oh my goodness, Choose Compassion has already linked our summary judgment playlist. Choose Compassion, I have to say, the mediator of my dreams, the sun, the moon, and stars of I guess you're not a mediator, you're a moderator. The moderator of my dreams, the sun, the moon, the stars of moderation. All right. I don't know what this means. David Almendara says, Tegrity Farms. Oh, is that an integrity reference? I'm going to take that as a compliment to my integrity. I don't know if that's what you meant, but I'm going to go ahead and take it. Hazard BLK Spirit. I assume Hazard Black Spirit. What happens if an employer falsifies documents in your personnel file? Well, can you prove it? Because if you can prove it, then you are going to blow their credibility out of the water, and that's amazing. Isaac's Trade says, haha, you got to be careful with the internet weirdos. Next thing you know, you'll be MIA. Yeah, that's real. That's real. We've had some issues, and it's not even just like disappearing or having something bad happen to me. It's like a gentleman who ran up on me and like forcefully like surprise hugged me. And a surprise hug is a lot like a tackle if we're on the same page there. It's just a person you don't know coming out of like your blind spot, trying to like throw their arms around you, right? And one of my concerns is like, well, God help me if I had like a box cutter in my hand, like if I was going to get the packages from UPS for the day and I just had a box cutter in my hand, like how do I know what this person's just charging me? I worked in bars for a decade. I'm not a stabby kind of guy, but like if I panic and I'm like, you know, like that's scary stuff, right? And then all of a sudden I got a case on me for like stabbing a guy who just, I guess, wanted to hug me, but it was a non-consensual hug with a person I don't know who like snuck past security in my building. And, you know, that's scary. So there's just layers and layers and layers of like unacceptability with that kind of thing. And it's easy for me. You know, I'm not like a big guy, but like bigger than most. And, you know, I worked in a lot of bars and whatever. So like I have a slightly greater than usual ability to like take care of myself, but it's still scary without a doubt. And I got to be realistic about that. And I get advice from a lot of you know, quasi-famous women on the internet and about what they experience with stalkers and stuff like that. And it's easy for me to like, be like, I don't need that. I'm not you. I'm not some like beautiful presenter on the internet. And their point, all of them, is like, yeah, so like beauty's in the eye of the beholder. Like people feel what they feel about you, and like, or the desire to like hang out with you, or the desire to hate you, whatever it is, like that's not really, it doesn't stop existing because you're not like a woman, or I don't know, like a Manhattan 10 or whatever, however people rate women's humans attractiveness at this point. Like it's like yeah, so I guess I just got to take it seriously, which is hard to do sometimes. Oscar Almeida says, what number do you believe is considered to be too high for a settlement offer? I asked for 6 digits. Can offering a low settlement to the defense attorney come back to bite you in some way? So listen, every case is different. There is no universal high number. There is no universal low number. Every case is different, and you calculate the differences for each the damages for each case individually. And so what I would recommend to you is hit up our damages calculation playlist to get a feel for your damages and if you're in the correct ballpark. Now, David, I'll also say this. Going low, too low, can make it difficult to get high again, right? Like if you're just currently, if you're feeling like, listen, I want to be done with this. I would take 40 if I could get it in the next month and then just be done with this. But if I want to go the long haul, I want more. Okay. You can say that, right? You can go to them and say, hey, one-time offer. I'll take 40 this month. If you don't do this month, we're going to federal court. We're going to the big show. It's going to be way higher, but just for this month only, if you give me 40 by the end of this month, I'll take it. There's nothing wrong with that. They might try to stick to 40 later, but at the end of the day, you can just be like, listen, I told you that's not going to get it done now. And, that's a reality. YouTube user NYC Damages, just BT dubs. We have 6 minutes left. 6 minutes left in this chat. We have 55 concurrent. Well, I guess it's live stream, not a chat. We have 55 concurrent users and 43 likes. Remember, the like button is free, and it does help us to help more people just like you. NYC Damages. Can you talk about the amount you file for in a federal lawsuit, suing for XX dollars, and the amount that you want in settlement, or what you enter in the demand letter? Are they the same? Different? So first off, don't enter a demand number in your demand letter, because it is possible, theoretically, the demand letter appears in an evidence binder later. Not the end of the world if it does that, but you don't want the jury to look at a document and say, well, the plaintiff only wanted 500 grand back, 9 months ago when this all started, 18 months ago when this all started. They only wanted 500, so let's give them 500. Problem. Because now that 500 number was hedged for risk. All settlement demands are hedged for risk because no one wants to find out what the jury's going to say, right? There's a lot of risk that goes on in the course of litigation. You can win, you can lose, you can win and win less than you were offered in settlement. A lot can happen. Now, to the first part of your question, the number you seek in settlement is different. That is a settlement demand, and that is different from what you could hope to win at trial. If you were embracing all the risk at trial, everything that could go right, everything that could go wrong for you, you will go for everything you could possibly win because you no longer need to hedge for risk. You no longer need to engage in the logic of, okay, I've got a good case. I think it wins more often than not. I think if I run this trial 6 times, or if I run this trial 10 times, I think I win 6. So I could hope to win $1 million if I go to trial, but I could hedge for risk and ask for 600 grand, and that might make sense. That's, a really shorthand version of how you might hedge for risk. And we're not going to get into the higher, more complex forms of risk hedging because I'm not a mathematician, and my understanding of those are sufficient to apply the formulas, but insufficient to understand the finer points, right? Because those strategies are created by mathematicians. So your settlement demand is hedged for risk by definition, almost always. And what you would go for at trial is not. Okay. YouTube user Choose Compassion says, isn't isolation a form of retaliation? Sure is. Choose Compassion. Sure is. YouTube user Shane C says, what are some underutilized legal strategies employees can use to protect themselves when navigating workplace disputes, especially regarding reasonable accommodations? So get everything in writing. Let the reasonable accommodation dialogue play out in writing to whatever extent you are able. That can be a huge, huge benefit. Also, don't be afraid to ask for time, right? There's a lot of times so that an employer will meet with an employee and engage in reasonable accommodation dialogue over a table in a conference room. And they'll say, hey, we can do this. Do you accept? And you can say, oh my goodness. Okay. That is an offer. of an accommodation, and I thank you for making that offer. Let me carry this to my doctor and have a conversation about whether or not that would meet my needs. Will this actually accommodate my disability? And they can't really say no, right? At the end of the day, there's a give and take. It doesn't, if they say, no, you can't talk to your doctor, they're not really engaging in good faith. We're already like kind of in the realm of like, are they properly engaging the dialogue? Is there a claim there? It's not a great claim yet, but like they're playing with fire already. So stand firm. Just be like, I do have to talk to my doctor, and then go talk to your doctor. If you have counsel, talk to your attorney. Let the doctor tell you what will and will not get this done in terms of helping you as an accommodation, and let your attorney look at the communications and say, oh, that was a good idea. That was not a bad idea. Like this was not ideal. And, let the doctor and the attorney earn their keep. They work for you, right? So it's the least they can do. Isaac's Trade. Oh, Isaac's Trade says, run them likes up, chat. I like this new Isaac's Trade. Welcome. Such a nice benefit. Such a nice addition to our chat room. Exec Monster X says, are there any legal ramifications against the employer who withheld money I had to pay taxes on based on a court order? Sure. Yeah, probably interest. They'll probably be charged interest. There might also be penalties. All right. Last question. Two questions. NYC damages. David Almendarez says we should only allow choosing compassion to ask one question per hour. David Almendarez, choosing compassion is a moderator in this channel who is helping us to run this live stream out of the goodness of their heart. They can ask a question every 30 seconds as far as I'm concerned. And they're always good questions, so I have no problem with it. Exec Monster X says, are there any legal ramifications against the employer who withheld money? Oh, I already answered this. NYC damages. Thinking of becoming an employment plaintiff side employer. I think you might mean a plaintiff side attorney. How do you deal with different outcomes in similar cases under different judges, legal teams, etc., especially if you, me, have a strong sense of justice? So how do I say this? Becoming a plaintiff side attorney in the realm of employment law will beat the sense of justice out of you. This is the reality. There is not, the justice system is not built to produce justice. It is built to produce outcomes. And the best outcome you can produce for your client in the realm of employment law is usually money. And the reality is that a lot of things that happen in our field, things that happen to our clients, tend to be things that are sufficiently horrible that money can't really make up for them. Doesn't mean our clients don't want money, and it doesn't mean that we're bad people for getting our clients money, but it does mean that you're going to sit there and realize that, like, a rape victim, a sexual assault victim, somebody who was put in a dangerous circumstance because of their race or their orientation, their gender identity, whatever it is, $1 million doesn't make up for that. Like, nobody in the world is like, oh, sure, my life was put at risk, but I did get this $1 million. Or, sure, I'm going to live with the scars of what happened to me for the rest of my existence. But at least I got 7 figures. Like, that's not how humans work. The money helps. It can give you time to heal. It can give you resources. It can give you a runway to move on through life. It helps. It's not justice. So I will say to you, NYC Damages, I think you would be an amazing potential person to come to this field. We don't serve justice. We can hurt bad people. We can make them pay. In my opinion, it never rises to the level of justice. Just a bummer. It's It's a bummer. Susie B. YouTube user Susie B. Last question of the day. Hey, Vince. If union contract language allows for individuals to be treated in a discriminatory manner, does the contract override state laws? Beekeeping at your farm as well? Well, first off, Susie B, I am talking with an apiary about moving beehives onto the farm. We do have an issue with bears in this area, so any beehives we get will have to be surrounded by a cage of electric fence. But we're pretty used to that. We keep a lot of animals behind electric fencing anyways, because it's a really easy way to let them graze and be safe in our pastures and stuff like that. So it's, we're no strangers to electric fencing. I definitely would like to have bees on the property. I want to be super pumped to produce honey here and like a mead product. The wine we made was the most profitable thing we ever created on the farm. And it was all the wine we made was gone in like 2 months. And it was without a doubt the most profitable endeavor we ever engaged in. Even more profitable than turkeys, honestly. So yes, absolutely bees. In terms of the union contract allowing people to be treated in a discriminatory manner, I guess I would need the details. Like, if the union contract says you can treat people differently on the basis of race, no, right? If the union contract says the managers have discretion to place people in a given role as to what they think best fits the needs of the business, yeah. And like, I guess your point could be like, well, it allows them to discriminate because they have discretion. Yeah, I mean, listen, the laws are still in place. If you're choosing people based on race or any of the protected classes, race, disability, religion, gender, whatever it is, right? There's, depending on where you are, somewhere between 20 and 30 protected classes at this point. The employer having discretion doesn't mean they can then discriminate. So it's going to depend on what specifically you mean. But generally speaking, there's no union contract that can subvert federal or state law in that way. Although you will find certain union contracts that like override things like New York PFL that paid them to leave in New York. Like there's union contracts that negotiate groups of employees out of that program for whatever reason. It's just a reality. But generally speaking, no, the union contract does not override federal law or state law in most cases. Everyone, it is 6:05. I went 5 minutes long. We have 48 concurrent viewers. We were much higher. I think we're close to 60. We have 48 likes. Thank you so much, everyone. I know there's questions I'm not getting to. I'm only doing an hour today. I guess an hour and 5 minutes. And I got to go get my maple syrup. Well, get my maple sap so I can make syrup tomorrow. And it's liquid gold. And I want to answer all your questions. I want to help you all, but I only got an hour or something left. So farewell, everyone. Like, subscribe, comment down below, share the channel so it may grow. Take care.